Now, how do we start? The issues are so many. But first of all, I think it's good to give you guys the opportunity to hear what your analysis of the judgment is, what your analysis of the judgment that acquitted Alfred Agbesi Woyome is. Some have come very hard on the judge as having also done some, sloppy work, quote unquote. I'll start with you. I can see that you have marked every bit of it. What's your judgment of the judgment?
Well, thank you very much. In the first place, I would have been surprised if a different judgment had been given.
Wow.
Yes, that's my general opinion on it, even though I have quite a number of concerns regarding some of the statements that were made by the court, some of them obviously being obiter, and the rest of it. And then also...
Okay, my listeners are not all lawyers. In fact, the majority are not lawyers. Some of them being obiter means what?
Well, in True, we call it mogo.
Mogo.
Yes. Okay. I mean, it's not so much relating to the matter at stake. But,
okay.
I mean, things that you can just bring into it to relax the people listening to you and things like that. But that's just by the way. And then also, because of the fact that we all know an appeal is pending, I would like to express myself in terms of the submission that was made by our good friend Dr. Ayini here, even though the appeal had been filed. So I would rather want to relate my submission in connection with what he said and the statements that have been made by them. I mean, one that comes out is if the court, at the end of the prosecution's case, dismiss submission of no case, then under what circumstance can the court, at the end of the judgment, still say that the prosecution was unable to prove their case beyond reasonable doubt against the accused person? Of course, the issue of what is meant by prosecution establishing a prima facie case at the end of its case has become controversial, and even now judges don't appear to agree on what exactly the prosecution is to establish at the end of the prosecution's case. So I did some research, and I came by Justice Ayebi's decision in the Popular Yana case. Very comprehensive ruling on submission of no case. That's Republic versus the Jisu Idi.
But on the determination of the prima facie also, Justice Anthony Yeboah has a fantastic, very elucidating points to make on that.
He does as well. Yes, so Justice Ayebi referred to quite a number of cases, and one of them is what we have here, State versus Ali Kassina. State versus Ali Kassina, where he states, and I quote, "It is now settled that the question of the judge is not whether there is literally no evidence, but whether there is none that ought reasonably to satisfy the jury that the fact sought to be proved is settled." Then also he refers to a practice note issued in the UK by Lord Parker, CJ, when he states that a submission that there is no case to answer may properly be made and upheld, A, when there has been no evidence to prove an essential element in the alleged offense, B, when the evidence adduced by the prosecution has been so discredited as a result of cross-examination or so manifestly unreliable that no reasonable tribunal could safely convict on it. Then the last point, which I will refer to continuing, that if, however, a submission is made that there is no case to answer, the decision should depend not so much on whether the adjudicating tribunal would at the stage convict or acquit, but on whether the evidence is such that a reasonable tribunal might convict. If a reasonable tribunal might convict on the evidence so far laid before it, there is a case to answer. So the question you ask is, at the end of the prosecution's case, will the reasonable tribunal convict? And if you ask, in my view, the accused person to now lead evidence the question to ask is, has the prosecution been able to establish some kind of case against the accused that a reasonable tribunal will not convict? You get the question?
But it doesn't imply an automatic conviction.
No. Yes, but that is where the controversy now is. Now, and even a lot of people have expressed their views, and I'll just refer to the final point on this matter, because the issue still ranges as to what exactly is the prosecution to establish at the end of the prosecution's case. Interestingly, in this same case, when the application for submission of no case was filed, the state prosecution vehemently opposed it on grounds that the judge cannot discharge the accused at this stage because the prosecution's case can only be made after the entire case has been heard, i.e., prosecution has given their evidence, the accused person is called to give his evidence, he has called witnesses if he wanted to, and the case is determined. It is at that point that, according to the prosecution, well, the ages, at the time of this case, the Yana case, that is the only time that the court can firmly state that a prima facie case has been established, to the extent that it has established a case beyond reasonable doubt against the accused. And that to ask what the accused, the prosecution should do, should elicit the answer that at the end of their case, they should be able to have made not just a prima facie case, but a prima facie case that should also amount to a case which has been established beyond reasonable doubt.
Okay.
So that is where then the question that obviously comes out is, so if the accused was asked, or in this case, the accused was indeed asked to also lead evidence, then what it means is that then the question will be asked, had the prosecution at that point in time established a prima facie case?
Yeah, and so yes, at that initial stage they did, and that's why that's what the judge said emphatically.
No, but at that initial stage, if they had done so, then the accused person should not have been called to give evidence.
After they had established a prima facie case.
No, they filed application for
a submission
of no case,
and the judge held that a prima facie case had been made. And
yes.
So the submission of no case
was
had
dismissed.
Been dismissed.
Yes, and so the point is that by the literature, when you say a prima facie case has been made, then it means that the prosecution has been able to establish a case beyond reasonable doubt against the accused. No, that is
not the position of the law.
Please, please, and I will come to that. I will come to that. That's why I'm saying that there has been various positions on this one, on this matter. So let me refer to
only one position.
Pardon? No. So if in that case the accused the prosecution has not established a prima facie or a case beyond reasonable doubt, what is the accused person being asked to do? No. What is the accused person being asked to do? Is the accused person the one to assist the prosecution to establish his case?
I think we should really settle the law.
Right. Okay. So let me bring Atacha in here.
Yeah.
That initially a prima facie case had been made means that now you have the opportunity to also show that indeed you are not guilty.
Precisely. And it is not the end of the case.
No.
The end of the case is when the accused person has testified, brought in witnesses as many as he can fill, cross-examination has taken place, then the burden also is raised again. That has the case been proven beyond reasonable doubt? Having regard to the evidence adduced by the prosecution and, of course, the defense as put forward by the accused. So this is very, very important for us to understand. But for me, these are fine distinctions.
Before you move on, I mean, still on the law, I think that is, my little friend earlier said that the position is confused. And you referred to Mr. Justice Ayebi's judgment. I agree with you. But strangely enough, the reference was to Ali Kasina, which is 1962 or 63 case. You see, if he can go, he goes back to 1962, then it means that the matter is very settled. The test at the end of the case of the prosecution is whether, they've raised sufficient evidence enough to call upon the accused to answer. Now, the test they say is that scintilla of evidence, even the slightest evidence that connects you to the crime, it's enough to call you to come and open your defense or explain. But that is not the end of the case. Otherwise, our jurisprudence will be turned upside down. Our jurisprudence is that the prosecution will have to put up their case, the defense will have to put their case. But you don't say that because the judge says that at the end of the case, there's a prima facie evidence. It means that the accused ought not to speak. Then you turn the law upside down. I think I'm saying that we must agree as lawyers that at the end of the case of the prosecution, there's an opportunity to be given. That's the opportunity clause for the accused to respond. You get me?
Can I just have a minute? At least I will refer to R versus Ojojo 1959, which is also quoted in Justice Ayubi's decision, where the Court of Appeal asked why the defense was called upon if there was doubt in the prosecution's case at the close of it. Consequently, the court quashed the conviction of the accused by the trial court. And this case supports the view that the standard of proof at the end of the prosecution case should be beyond reasonable doubt.
Well, that is but that is in the ultimate evaluation of the entire
case at the end of the prosecution's case.
Okay, so I'll need us to move away from prima facie.
I just so that we don't confuse our listeners. At the end of the case of the prosecution, there's a different standard that is used to evaluate. Has there been some evidence that connects the accused to the case? If yes, the accused must be called upon. But after the accused has given his evidence, the totality of the evidence will be evaluated by the judge. And at that point in time, the judge must decide whether, the prosecution have established their case beyond all reasonable doubt in relation to the evidence given by the accused. So,
if the accused refuses to give evidence, the court can then still rely on the evidence of the prosecution.
That is another option. Even if the accused refuses to give evidence, then the judge will have to move to the second level to also evaluate whether, even without the evidence of the accused, the evidence that's been laid before the court is enough to prove the charge against the accused beyond all reasonable doubt.
Very recently, the judgment I referred to, a very erudite judgment given by Justice Anthony Yeboah when he was determining the questioning, the test of prima facie. He made a profound statement, which I think is actually simplifies the whole process. He says that, and this is in Republic versus Eric Odai and others, 2014. He says, to determine whether there will or will not be a waste of time or resources in prosecuting the accused person. I should actually be starting here. He says that the available facts or evidence must be of such a nature that the prima facie case has substance. And the prima facie case has substance where it will not be a waste of time and resources to entertain it. So from the very preliminary stage, there should be some material, he refers to such things, to suggest that we are not wasting our time if we are going into the case.
The person is not connected at all.
Let me make a clarification to support what my senior is saying. And it's very simple. The prima facie case is not at the end of the trial when the accused person has been called upon to give his defense together with witnesses. The prima facie case is when the prosecution has concluded this case, and you can see that on the face of the evidence, there is a case for him to answer. That is what it actually means.
Correct.
But the prima facie case can never abide the very end of the trial. So this is what I think the jurisprudence is so clear on that.
So on the back of that, maybe just a point where I think that the attorney generals are also disturbed. Just on the back of the question of prima facie. The judge concludes on page 31 and 32, the very last paragraph. He quotes from Justice Atuguba in Chachuchikata versus the Republic. And this is after he had said clearly that they had been sloppy in the way they went about the case. And he says, to borrow Atuguba JSC's words in Chachuchikata versus the Republic, with regards to this case, the prosecution's case is heavily riddled with alluvial exculpatory evidential bullets and therefore does not establish a prima facie case. When I got to that point, I put a question mark.
Yes.
And therefore does not establish a prima facie case against the appellant. This is where he has 2 more sentences or 3 more lines to acquit Mr. Woyome. The question is, he had made a determination there was a prima facie case at the start. Then he comes to the very end to his conclusion and quotes Judge Atugba to say prima facie case has not been made against Woyome.
You see, I hold a humble view that this piece that he quoted at that point in time was irrelevant or misapplied, the Chikata case, because that has also to do with, making a submission of no case when the prosecution has concluded this case. But just go ahead and see that this error, I believe, is an error and a contradiction. He goes on to say, and in the instant case, I'm of the considered opinion that the prosecution has failed woefully to prove beyond all reasonable that the guilt of the accused. So he went ahead now to apply the proper test. I've looked at the prosecution's case and all the facets and the dimensions of it. I've also looked at the defense. Now the test, which is all over the world, the criminal jurisprudence, has the case of the accused been proven beyond reasonable doubt? And that is the end of it. If it's not been proven beyond reasonable doubt, politics aside, whatever we are doing aside, how much emotive we feel about this case aside, that is the position of the law. Okay. And that is the problem that we are facing. And let me clear this, for just a second, before you proceed with the next question. You see, when we get emotive and when we get passionate in a very poor background, 51 million Ghana cedis, it's a lot of money. You see, so when we measure this against the fact that some pregnant women might be sleeping on the floor because we don't have beds, we can get very agitated. But when we come to that forum called the court of law, it is not about how we feel. It's the prosecution leading credible evidence to show that indeed and in fact the accused person should be convicted. So if you feel so bad about the situation but the prosecution is not able to prove it, I'm afraid the outcome is sure. The accused person will be acquitted and discharged. Okay. That jurisprudence we can't change through the newspapers or whatever.
I also think that quotation, what I'm at time, is just what in law we term a surplusage, where a judge decides to go one step more to elaborate or explain away. But it's not the core.
All right.
It's not
so
the core.
Now let me take your substantive view briefly on what you make of the judgment.
Well, I'll crave your kind indulgence because for me, you can never understand this judgment unless you situate it in the context of this case. And I'm afraid I have to say that this case has serious political ramifications. We need to bear that in mind. This is the single case in the realm in which it defied presidential orders. Don't pay the money, and it was paid. This is a case in which the Supreme Court has also declared in hard terms that it was a situation of create, loot, and share. This is a case in which an Attorney General is on record as having shown that the man is worthy of the payment. And do you need to come back at the end of the day and say that there is a serious criminality, and in the criminality, the man did not fetch the money from the table of the Attorney General. The Attorney General was persuaded that the man was entitled to the money. Are you now going to say that we should charge the Attorney General? And this is a case also in which the Attorney General's department had officials who others perceive, were complicit in the way the matter was handled. Is this same Attorney General's department that is being called upon, maybe with another person, in the saddle, to prosecute this case? With what weapons are you going to prosecute this case? So it is from that perspective that I want people to see that it is not a simple case like an ordinary case of defrauding by false pretenses or causing financial loss to the state.
So you are saying in effect that a lot of things come to play other than just what was put in the court for a determination, whether or not the man had defrauded by false pretenses and had caused financial loss. The judge will be looking at his back and say, look, beyond this, I should be aware that this is there are serious political ramifications, and that should also influence my judgment?
In fact, that's what I'm saying, but you could see that the preface I'm giving is right in the center of this decision, in which the judge was asking, for instance, why is it that you didn't fill the Honorable Betimo Drusu? Why is it that you didn't call this person? Why is it that you didn't call this person? So I'm asking you, how can the Attorney General's Department have concrete evidential support for the payment at one breath, and then you turn around and come and say that, look, this man has defrauded us, when you sanction the payment? So these are the matters of serious consequences that we need to look at, and it's all contained here. But one of the things that I found, which, with all respect, gave me an impression that this whole trial was stillborn, I'm afraid, is what is found here. I was very shocked to see this piece of...
The conclusion you come to is that the trial was stillborn.
The trial was stillborn, okay, with all respect.
Now, justify that.
Yes, my justification is very simple, that you see, whenever you want to prosecute an individual, you should bring incriminating evidence, and it's so critical, as against exculpatory evidence.
Okay, you are now referring to almost speaking like the judge here.
I'm telling you, every criminal trial anywhere in the world. And therefore, if the prosecution should furnish the court with evidence that exculpates the accused person, no matter the intellectual dexterity of the judge, no matter the mental acrobatics he wants to display, at the end of the day, you cannot convict a man when his accuser's evidence sets him free. Fundamentals. And I don't see how we can, come to terms with what is captured in this decision. And let me show you something that I found very interesting as to how this document was tendered. Through the prosecution witnesses. I think it's gotten to do with a memo of serious consequence.
The famous Exhibit 32.
Yes. For me, it frightens me.
It's an internal memo.
It's an internal memo which, to all intents and purposes, is supposed to be a confidential communication amongst the departments of the individuals in the Attorney General's Department. But this memo was tendered. As to how it got tendered, only God knows. But let me show you one.
This is where Asan Kuma says, without any equivocation, that the Attorney General's Department leaks, to the extent that this document found its way to Woyome's hands and was used for the purpose that it was able to achieve. A document in which the state attorneys are saying that we feel we do not have a case against Woyome, and so we are not confident in defending this case. And they are referring to the original case at the commercial court.
You see, this also feels a perception that this is a create and loot and share.
How?
In the sense that, how could you, for all the arguments you can make, show that this case is not good? The prosecutors of the case, the trained minds are saying that even the weapons are not there.
They were not talking about this trial. They were talking about the commercial, the case at the commercial court.
Well, it is even worse, my good man, because in this trial, the threshold, not only that, the threshold is higher. So if you can't succeed in, civil, where proof is based on the balance of probabilities, then I come back to my first premise that the whole thing was stillborn. How are you going to go about it? So when they have actually said that we don't see that some of these chief state attorneys have confidence in the case to prosecute this matter.
I've seen you have done a lot of markings, but you are not making the references. Really.
No, well, maybe because of the fact that you have said a lot about some of these things already. So let me just quote something for you to see. I find it very sad. The other issues, I'm quoting from page 20 of the judgment. The other issues, whether we would want to put former ministers on the stand. Oh, this is very frightening. Who may be embarrassed under cross-examination in view of the circumstances specified above. So therefore, there was a clear case of what we call concealment of what they believe would damn their case. So there's a calculation from the Attorney General Department that if you should ever fail these ones, then they will be embarrassed. I think another word of saying that the case will collapse. So therefore, what kind of criminal prosecution are you doing, choosing here? Let's try and entertain. I'm of the view, I could come to some conclusion. This was some of a case of some entertainment value. Just to show that where we wanted to, prosecute Woyome.
That's very harsh. A case of entertainment value.
I can tell you, I will repeat it. Because
serious chambers like the Attorney General's take
listen,
a case to the court and you say it was just a matter of entertainment value?
It was of entertainment value insofar as they didn't believe in the case. But let's do some attempt to make the public happy that we are desirous of prosecuting the man who we have signed at one bread that is entitled to the money, but now we have to reprobate that is not entitled to the money. And then at the end of the day, let's say that, well, we did our very best, but the judiciary set him free.
The move to appeal this does not support the point you just made.
Well, I can also tell you that when it's stillborn, an appeal cannot improve the record of proceedings. You are a lawyer of substance. You know what I'm talking about. You see, there's nothing that the Attorney General is going to do to shore up the record of proceedings. If you gave ammunition to your opponent, and then those ammunitions were used against you, your case, your very case, then where are you going with this matter? May I quote with respect some of the things that were said to about...
Okay, so now find the time to wrap up so that I go to Nana.
Yes.
We want to deal with the matters that have come up as far as the case is concerned.
Okay, let me refer you to one particular embarrassing thing that I found. Yes, okay. That is very, very important for us to see. I want you to understand, well, when we're talking about defrauding by false representation, pretenses. A false representation is made. To who? The false representation was supposed to have been made via the petition to the Attorney General. But then the Attorney General now says, with my training, that was not a false representation. And you can find the judge quoting, at length, a letter coming from the Attorney General, and that is Exhibit AH. And this was a letter which pushed the payment. It was a letter from Honorable Betty Modidrisu to Dr. Dufour. And I don't know whether we have the luxury of time. And it is so clear that there was a passion coming from the Attorney General's department that the money should be paid. So where is the defrauding by false pretenses in this matter?
But it doesn't matter that the same Attorney General, Betty Modidrisu, subsequently went to the court and said, we paid under a mistake.
Well, if you pay...
Under a mistaken belief that we owed him. We have discovered this very critical letter that suggests that we didn't owe him, so we made a mistake.
So that means that a material witness who should have come to say that I made a mistake, of course a monumental mistake, but that is permitted for people to make mistakes. There's nobody who is perfect. And therefore, what I wrote, I repudiate. And therefore, this man didn't have the contract to have what I have been hoodwinked or bewitched. And that could have been a very paradigm shift in this whole trial.
Okay, they say they couldn't have put her on the as a witness because she's subsequently been heard to say the payment was justified.
Well, so how can we reprobate and approbate? So this is a kind of monumental contradictions in the case that I don't see how any serious judge will find a conviction
against the prosecution.
Yes,
that's what you say.
A lot of them.
And as far as Atachan is concerned, this case was only of entertainment value and it was stillborn. Very harsh words there. Nana, what's your evaluation?
Yeah, well, I wish I were not drawn into this debate because I've been on this panel here. Yeah, the two of us, we've been here in this studio 4 years, is it 3 years, 4 years ago?
Yeah.
And I'm not going to change my position. And I must say immediately also that a caveat that I represent Mrs. Betty Modidrisu. Everybody knows in this country.
Right.
We've been to the, what do you call it, before you, at the PAC, Public Accounts Committee, and I've said the same thing. You see, I think that I agree with Mr. Atachia. That's my view, of course, that this case was stillborn. You understand? The Attorney General came to meet a case, and she's continuing. That's what it is.
I'm interested in hearing what you have to say, because I didn't expect this to come from you.
Yes, the Attorney General made this case. But could the Attorney General have revoked the trial in the middle when she was appointed? Mr. Atachia has raised some very interesting points about the political ramification and whatnot. And it's not only one side. It's not ONDC. They throw at each other. You understand? That is a problem we're facing. So people are simply not looking at the case from the straight legal perspective. And this is where I was 2012, up to today. I said that, look, matter should be looked at from a political viewpoint. You have to look at it from the constitutional angle. You must look at it from the criminal
angle. The Supreme Court has dealt with that. So
I'm coming. No, yes. So from the constitutional angle, we can look at it at the administrative angle, and then we can look at it at the criminal angle. And I said that the constitutional angle, as you rightly said, the Supreme Court, in the middle of it all, has come out that the payment ought not, or that contract was, unconstitutional.
Null and void.
To say that it's unconstitutional, null and void, does not mean necessarily that it was tainted with illegality in that sense. It is unconstitutional. Yes. So that is a position. Now, I kept saying at that time, 2 years back, that Mrs. Betty Mould Idrisu probably could have erred administratively. But it doesn't matter how much or how far you look at it. The so-called administrative errors, multiply it 100 times, 1,000 times, cannot amount
I'll
to
allow you to deal
criminality.
with the administrative aspect and whether it amounts to criminality. But to the point where you say the Supreme Court only made a pronouncement that to the extent that the transaction or the contract that he sought to rely on and under which he benefited from this amount of money was of some international, economic transactional nature and subject to Article 1815, and that didn't get parliamentary blessing.
Yes.
It was null and void.
Yes.
And you say that doesn't mean he got it wrongly or he did anything wrong. The Supreme Court said more than that.
Yes.
And I quote what a favorite part of that judgment for you. It says, under the circumstances of this case, there was absolutely no sound legal basis for the pursuit of the claim by Waterville and Woyome against the government of Ghana. It should have become very clear to whoever was in charge of directing affairs at the AG's office that the claims of Waterville and Woyome against the government of Ghana cannot hold water.
Look, Samson.
Yes.
I've responded to this in this group before. I've said that portion of the Supreme Court judgment is slightly, with all due respect to my unfortunate. In any case, it's orbital. Those administrative officers, they were not called. They appear before the Supreme Court. So we can't make a ruling in respect of their conduct at that point in time. It would be unfair. You see, now I'm not saying that that is a viewpoint. I'm just saying I don't want to be engaged directly.
You are still evaluating this judgment.
Absolutely.
And you say you agree that it was stillborn, and you're saying that something may have been done under some mistake or something does not mean it's a crime. So can you proceed and tell us what you think of the judgment?
I never said that something was done. A mistake was occurred. I said may have occurred.
Okay.
Look, at the end of the day, the only judgment, real judgment, in terms of evaluation of the evidence of what actually happened, the participant, is the judgment. This is before us now. That's the criminal case. Because we don't have the civil matter. You get me? The conduct of each other. And I'm saying that this judgment will prevail. The Supreme Court judgment only relates to a constitutional matter.
Right.
Yes, the criminality of it is there. And in this, I think everybody else should pause. All the comments you are making, so let us go and study what the judge said, what the High Court judge said. Have a lot of patience, put the passion behind, and read the evidence. The man says that there was not enough evidence, adduced before him. I know what it is to prosecute. It's unfortunate if the evidence wasn't forthcoming. But I was saying that as far as I'm concerned, that trial ought not to have started in the first instance. Because, like I'm saying, yes, the Supreme Court said it was unconstitutional, but that the issue of criminality had not been dealt with.
You are known to have some amount of influence within the government or within its legal arrangements. Didn't you give this advice that this ought not to have started?
Well, I will respond to that. I will respond to that. There are matters which are not for this debate here. You get me? But I've stated clearly in this forum here from 2 years ago that the attempted trial, putting on trial of Mrs. Betty Modidusu will be stillborn. You get me? All the claims. We went to the police headquarters with Mrs. Betty Modidusu. There were how many? 20 or so police legal officers with the director of CID, the CID board. They asked her. She put her case where I was there. The people say, then where is the problem? You understand? Today, we are back saying, Mrs. Betty Bodu should be tried and whatnot. We must draw a distinction between administrative acts, constitutional acts, criminal acts, and what's the other? Until we are able to draw those lines, we will run into problems.
At least she's said to have been a material witness. Precisely. The judge so desired that she would have testified, and that may have assisted the state. Precisely. We are now being told also that she was begged and she declined, at least to testify.
I think that there's a need for some clarification. I had the letter Attorney General on this, without seeming to contradict her. I've told you I represent Mrs. Betty Bodu in this matter. I've had some consultations with her, and that position may not be wholly correct. And I know that it is also buttressed by the fact that the Attorney General's Department wrote to Mrs. Betty Modidusu to that they would want to turn him in as a witness. That letter came through me, went to her through me, consulted, and we responded accordingly. And what we wrote back there, she has no objection whatsoever to be called as a witness, save two conditions. One, she is still under public oath, the oath of secrecy. It runs even after you've left office. So you must ask permission for it to be lifted. And secondly, she's been out of office for a long time. She will need to have access, to be given access to the records. Save these two conditions, she was prepared to.
And these were not fulfilled. Is that it?
Of course. I mean, if the trial goes on.
What's the process in lifting the oath of secrecy?
No. I've been a chief of staff. I've taken the oath of secrecy,
yes.
And you carry it till death.
So you say she's available, condition that the oath is lifted.
Yes. How
is it lifted?
No, normally we may have to. If the president, for instance, were to write a letter to say, lifted, go and release, or the court. The court is the court. There's an order. You can go to court. Rather, it should be lifted. Anybody who is being a public officer must be responsible. You can't just be a public officer, go out and say all kinds of things, even after you've left office. You understand? So, but the point I want to.
No national security implications.
No, I'm not talking about national security. I'm saying that when you take an oath, the oath of secrecy, among other things, it's in the Constitution here. It says that I'll keep whatever I hear secret, and that upon pain of punishment. You get me?
And it is the government, it is the state for whom you took the oath of secrecy.
Yes.
That is inviting you to come and testify. Does that not automatically, take that away?
Listen, the oath of secrecy is in the Constitution right here. It says, I so and so, in the name, holding the office of, say, Attorney General, do in the name of Almighty God, swear, solemnly affair, that I will not directly or indirectly communicate or reveal to any person any matter which shall be brought under my consideration or shall come to my knowledge in the discharge of my official duties, except as may be required for the discharge of my official duties or as may be specially permitted by law. So help me God. It's right here. So you can't, look, I'm saying that some people are doing the wrong thing. You can't
what I'm trying to understand is this. What I'm trying to understand is this. If there is anyone that will take a former state, officer on for breaching the oath of secrecy, it will be the Attorney General.
Or anybody under the Constitution. Anybody can do that. Anybody, our Constitution, want to. I mean, it makes provision.
So you anticipated that the Attorney General will ask that she comes and testifies in the interests of the state, and that subsequently somebody else somewhere would have taken her on for that?
No, I'm saying that every public officer, every public officer carries that burden. Sitting here, I saw so many things. I heard so many things in the past 19 years. How many years ago? I can't just be responsible and come and sit on Joy FM and say anything.
That's
a burden.
There is no secrecy when what you are trying to talk about is in the public domain. The documents were there. Even before the trial commenced, we saw, mountains of documents about this Woyome matter. So what is secret
which
about
one
what
is the public domain?
What?
You see, you don't take your inspiration from newspapers and then
documentary evidence.
But it should matter that the manner in which those documents were leaked.
Exactly.
Yes, but it doesn't become secret any longer.
Okay, now let me go to Kweku Bako.
Complaining about
Let me go to
leakage
Kweku Bako.
of Exhibit 32,
and Kweku Bako, after a thorough, a second reading or a third or fourth reading of the judgment, says that even if Satan appeals Woyome's verdict, I will support it.
Yeah. That's true, but this is coming from a street corner lawyer. I'm not about to assume a certain authority or a level of knowledge that I don't have. So this is a disclaimer. All those listening to me know that there's a limitation. But I have read the judgment over and over again. It is suspect. Look, the judge talks about the prosecution having been
sorry, this is not good, but let me share this with you. A very senior lawyer writes this to me. He says that the oath of secrecy does not apply in a court of law. A court will determine in what circumstances matters may be excluded. The oath is in relation to the rest of the world, save before a duly constituted authority. And this is a very senior lawyer.
Yeah, but I need to respond immediately to say that it's misplaced. This comment is misplaced. It is when you come to court, then this reference becomes relevant.
So why don't you make your...
No, I've said that the person say, I'm prepared to come to court, provided you assure me you lift it and all that. You see, they are making two mistakes. The different thing is when there's a legal matter before the judicial issue. Then you come to court, the court may decide, you apply, and then it's lifted. But when you are not in court, when you are outside, and you write to ask for that leave, that is not the answer to it.
No,
okay, wait. I'm interested in another thing. You spoke about where the state said calling these people might be embarrassed.
Precisely.
Isankuma speaks about the embarrassment principle, a very curious principle.
Yes.
That does not affect other former ministers from the NPP.
Yeah.
So Osafo Mafo testifies. Ajiman Menu testifies. They also took the oath of secrecy. Are you saying the court condoned a violation of that oath?
No. You see, I think that I've said that the problem with this case is that it built on suspicion and suspicion and whatnot. An officer lower down there in the Attorney General's department writes a memo indicating that, hey, this matter we are handling, wouldn't it embarrass, former attorney generals and other officers? And then you use it as meaning that is government's position, or it was meant to show up government's position. Who says that government had any hand in that discussion or in that write-up?
Very interesting. Kwaku, let's hear you now.
Clean this case of suspicion and political chicanery.
Let's hear you now. And when Kwaku is done, we will speak briefly to Yoni Kolendi. Yoni Kolendi disagrees with you on the question of how to deal with the oath of secrecy.
Well, that's
so
fine.
he will share his view briefly. Now, Kwaku, let's go.
Yeah, as I was saying, as a layman, so please let nobody think I'm talking strict law. The little I've read, and I've read a lot of judgments, both civil and criminal. This particular judgment, I insist, is suspect.
Is what?
Suspect.
Suspect. You're back to your biscuit too.
Something.
Yes.
I've looked at the written address filed on behalf of Woyome by his counsel. I've looked at the closing address by the Republic. I've got a lot of the records of proceedings, especially the significant witnesses that appeared. And I've read quite a lot of them. I've come to the firm conclusion that the judge did not advert his mind to all the issues that were put before him. And that for me is critical. Certain omissions in how he arrived at his judgment. See, for instance, if you go to the page 24 of the judgment, relative to the testimony by Mrs. P.W.6, Mrs. Leslie Dodu, listen to what the judge said. Nothing incriminating was said by P.W.6 Leslie Dodu. Her evidence was basically on the Public Procurement Act. She never said she knew the accused person or dealt with any documents from Vamed or Alfred Agbesi Woyome. It was therefore a waste of everybody's time to bring Leslie Dodu to testify. Mention would also be made of evidence of Honorable Yawosafama for PW2. The PW2 even had issues with the meeting at Akosom. Now, this is shocking. The lady from the Public Procurement Board, the relevance of her testimony or her presence in court was because there was this claim by Woyome that the tendering process was truncated, wrongfully terminated. And indeed, the judge, in coming to some of his conclusions, quoted Madame Betty Mode's letter of 29th April 2010 and Bartino Bro's letter to the president 16 December 2011. And actually roots his judgment on these two letters on basis that they are making the point, and this is he was quoting from Betty Mode. It is my opinion that this letter dated 5th August 2005. This 5th August 2005 is a concurrent approval by the Central Tender Review Board, formed the basis of a binding agreement. Repeat, the basis of a binding agreement between Vamed and government of Ghana. And the processes having been terminated wrongfully by the government, the claimants were entitled to compensation for services rendered. But Nodo had a similar line too. The judge uses these two letters and these 2 points made by ministers of state to say that the August 5th letter, 2005, constituted a binding agreement. Here we are talking of the procurement law. So to tell the world that the testimony of the Procurement Authority Board was a waste of everybody's time is shocking, to say the least. Apart from that, the lady went through the motions of the law, the Procurement Act, and showed categorically, clearly, that Central Tender Review Board concurrent approval does not constitute the award of a contract. It does not. And indeed, it is not the finality. There are many examples in terms of the procurement experiences, processes, and procedures. And this was critical because this whole thing, as you know, Woyome said, he himself publicly has said he had no contract with the state. So here he was trying to make a point that the termination of that concurrent approval, which he had a connection to do because he was representing VAMED, is what had created liability for the state. And so then on that basis, he wanted to be compensated. The judge, this is whole judgment, this is all he said about the procurement thing. Significantly, Woyome's lawyers took time and went into the Procurement Act to try and contest what this lady said. Quite a crafty one, quite, I suspect they did some good work there, but still unsustainable in my candid opinion relative to the procurement law and the processes as established and as practiced over the period. That's one area that I have problem. And so you see in the judgment, if you don't have the record of proceedings, if you don't have the procurement lady's testimony, you don't have even Woyome's lawyer's address, you would think that really, truly, the procurement thing was just a small aspect of the proceedings. Meanwhile, it was a serious aspect, and as I'm saying, because August 5th letter, which the Attorney General and then Deputy Attorney General relied on to suggest that there was a binding agreement, cannot be dismissed as something of no significance. That's one. Two, you come to the police, the letters of support. Again, this is critical from Bank Austria. We are talking here of somebody claiming that he had undertaken financial services, engineering, and had given a certain scope of what the financial engineering covered, totaling about 1.2 billion euro, and had letters of support from Bank Austria, which were subjected to the Financial Evaluation Committee, headed by Van Le Dossou. Okay, he was a witness.
Yes.
Now, the witness, Van Lusu, as well as the police investigator, Edward Odame Ochre, told the court and gave evidence to the effect. Van Lusu says, letters of support are not letters of commitment. I could quote them, but because I'm sure it will take too much time.
Okay.
And that it was not any commitment beyond that. The accused all along was using the letters of support as the basis to drive his case for financial engineering services payment. The policeman who wrote to Bank Austria and got evidence, correspondence from Bank Austria, tenders in this evidence with Bank Austria saying, and I think that one, it would be important to quote from the record of proceedings. This is what he said. He said, I believe...
Which date's record is this? At the first page, the very top.
Yes. This is 6th day of November, 2013.
Okay, please go.
PW9, that is the Edward Odame Ochre, police investigator. They asked a few questions. They used even the Ministry of, they used the Attorney General's Department, the Ministry of Foreign Affairs to get some mutual legal assistance before the Bank of Austria would respond, because they first raised the flag of secrecy. So they had to go through these diplomatic channels, and then these letters came. The policeman says, I believe was the first request made, and in that response, Bank Austria stated that letter of support did not and do not constitute any agreement to provide funding for any project in Ghana, and also not a binding offer from them. They stated that they did not provide any funds for CAN 2008, inclusive of other projects, any other projects. Those documents were to no effect in terms of any financial flow from Bank Austria to the government of Ghana.
You're saying the judge's reliance on this?
The judge relied more on what Batnodro and Betty had been saying, which was based on the petition of the accused.
Right.
Yes.
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 And he's using that to contradict what had come from Bank Austria, that indeed the claim that we had given any commitment was not true. I'm thinking that the judge must evaluate the things on a balanced level, look at it deeper. And indeed, the Supreme Court, in its ruling on both levels, the review, the ordinary bench, especially the review bench, if you read it, they cautioned not just lawyers, but also courts and judges. If you recall, I have it here, that they should be very careful, meticulous, and not that because anybody brings a case there and then they run with it.
They did not only caution. In respect of the lawyers, they actually cited and submitted asked the clerk to submit the judgment to the General Legal Counsel for further action against Woyome's lawyer at the High Court.
But with an eye on the earlier High Court ruling that procured the default judgment and the consent judgment, they actually made that statement as well, that they are cautioning courts and judges to be meticulous and vigilant, and not just rule on things like ex partes or no defense and things, especially when the national public interest is at stake and the amount involved is colossal.
These things.
I'm not a judge.
So therefore,
no, I'm not a judge.
Samson, I think that
what is
as a lawyer, I will not sit down as a lawyer.
No, let's hear another minute.
But as a lawyer, I wouldn't sit down for a non-lawyer to make evaluation and cast aspersions on the judge.
I have not done that. I've attacked the judgment. I have not made aspersions against the judge. I have attacked, I have criticized the judgment, and I'm entitled to do that.
The issue of evaluation of evidence, it's a very technical thing.
Oh,
you
so I cannot talk
disagree with a judge
then I must
on
go.
this and on that. But his conclusion.
No, but this is a judgment of the court.
Then don't invite me here for this discussion.
The court is functioning sufficient as far as the judgment is concerned.
Are you listening? You are a lawyer.
Then I don't qualify to sit here. You might as well ask me to leave.
Nana, with the greatest of respect, if you are attacking the judge's person, I will not sit here and allow it.
And I would never do that.
Because judges do not have the opportunity to also engage in this public discourse. And I'll be the last to do that.
It's true.
You remember how I took on Chachuchi Kata after the Supreme Court when he took Justice Eniyebwa on personally. Yes, Koku, let's go.
Yeah. So that's the point I am making. And there are many more.
The point is very clear that if there's a judgment and you disagree, you appeal.
Yes.
Oh, but that's why I said I support.
Let Koku finish his point. Let's Koku finish his point.
Look,
yes. Let him finish.
Your
in some
introduction.
2-3 minutes.
Yes, I'm
let him
finished.
finish.
Right. Your introduction triggered a repeat of my earlier comment that even if Satan were to descend on earth to initiate the appeal, I will back it. So it means that I appreciate the fact that this thing is subject to appeal in the court of law, not what I do here, say here. That's obvious. Is that not true?
Right.
But you have invited me to take part in this discussion. I appreciate the fact that I'm sitting with 3 lawyers. Indeed, 4.
No. Okay. Now hold on briefly. Very excited to have my learned senior and good friend Yoni Kolendi join us on the line. Good morning, Yoni. Hello, Yoni.
Good morning, Samson.
Great. On the question of secrecy, oath of secrecy, you say that it does not extend to the courts.
Yes, sir. And Samson, good morning to your very high and respected panel. Now, under the 1992 Constitution and in the Fourth Republic, there is a major paradigm shift that individuals and persons who may have been used to the exercise of political power and mandate, that eludes all of us. Number one, there is no authority, individual, institution, office, group of persons who are not subject to a court of competent jurisdiction in Ghana. There's nothing like that. Any person, any individual, any authority, from the first gentleman down to me on the street and in the trench, everyone, president to Joe Kojo, we are all subject to the law. So there's no right you have which is not subject to interrogation, investigation by a court of competent jurisdiction or other duly constituted judicial authority. So, oath of office, everyone takes an oath, all people in high office. If my Leonard Senior were right, then none of those ministers would have testified. The president can be called to a parliamentary subcommittee and ask questions. You just raise oath of secrecy and then it blocks out the court. It is an affront to democracy and to the rule of law. There's nobody above the court. So if you think that there is a matter, first of all, you can't refuse to go to court, by the way, without consequences. Upon appearance, if there is a matter in relation to which you think that it borders on state secrecy, you will communicate that consideration to the court, to the parliamentary committee, to the duly constituted judicial authority. The judge will make that determination and either decide that this is a matter that the court is willing to exclude completely on those considerations, or decide that this is a matter that should be considered in camera. It is not left to you, an individual authority, because you've been president or because you've been a minister or because you've been a chief of staff, to say that I have taken some oath of secrecy, for which reason I cannot come to court.
Did you hear Nana? Nana, read the Constitution read the oath of secrecy, in which there is a line that says, unless some permission has been sought.
Permitted by law.
Unless permitted by law.
Good.
And you are saying that permission is in the court.
Something, when you then read that Constitution as a whole, that oath he has read is not even a provision of the Constitution. It's a schedule.
It's a schedule, that's right.
In that Constitution, every power, every authority, every constituted person, you are subject to the court, including the president. That is why the court could have determined who will be the president of Ghana.
Okay.
You see, you can't circumvent the court. If you do that, you've buried democracy and the rule of law. You think that if the U.S. Senate or the Supreme Court summons Barack Obama, he can go and tell the court that he has an oath of secrecy. It is for the court to determine whether that is a valid consideration. If my Leonard Senior, Mr. Tudazi, is subpoenaed or duly brought before a court on matters relating to his time as Chief of Staff of Ghana today, of course, that's why I said the Fourth Republic. You know, because under the dispensation in which he operated, the transitional provisions decided to put a metal cast on some matters. But even those matters, there is jurisprudence to the effect that you cannot circumvent a court.
Is this particular oath not perhaps the major consideration why the president is not subject to our courts whilst he is president?
Criminal charge. No, that is not subject to our courts.
You see, now something. So if you sue the president must go to court and tell the court, for ABCD reasons, I think I'm not subject to be interrogated on this matter, and the court will so decide.
Okay, what I mean is that in the first place, you cannot sue him.
You can sue him. He has a defense that says that within X number of years, but he can be sued. Everyone can be sued. And if you are served, you have to go to court. If you don't go to court, the court will make an interrogation, make a determination either in your favor or against you, depending on what the issues are before the court.
Okay.
They're suggesting that there is some authority in relation to some matter that you can say, I took an oath of secrecy. Therefore, I can't go to court. It's not there, or that I need it to be waived. The court can waive every legal protection, encumbrance, limitation.
Okay.
Not an executive waiver.
So Betty Mould obviously was ill-advised.
Absolutely.
Something.
Otherwise, democracy will be a huge absurdity.
Okay.
Well, I think
thank you.
He's
making a last point. Yeah. Let's hear you. What's the last point?
Let me make a point.
All right.
Something.
Yes.
Point number 2 I'm concerned to make. You see, when judges sit and exercise judicial power, if you look into the 1992 Constitution, sovereignty resides in the people. the judges, the press, everyone exercises those powers on behalf of the people. When a judge has rendered a view, an opinion, a judgment, that judgment is binding on the people. But the people on whose behalf the judge exercises those powers have a right to criticize the judgment, to interrogate the intellectual reasoning and the legal reasoning of the judge, and to shred it, turn it upside down. But the borderline you don't cross. You must not do it in a way that undermines the authority, integrity of the court of the judge, or brings the administration of justice into disrepute. You cannot do it in a way, in a language that is scurrilous, abusive of either the judge, the court, or a judicial officer. So it's a tight line. So you can decide as a professor of law to do a review of the judgment.
That's right.
And right, but keep to this line. If you cross that line, you have exceeded your right and you'll be dealt with. That's what we call contempt of court.
Okay.
So Kweku is dead on that as a citizen on whose behalf the judges exercise judicial power, the people, we judge the judges and we judge them in these conversations. But the rule is, in so doing, don't do anything that will undermine the fabric, the structure, the institution, because we need the sanctity and order of the courts for order.
All right.
And pacific settlement of disputes.
We cannot live in the jungle.
One of
Thank
these
you.
tricky rights the law gives you, but draws a line which is so thin that if you are not careful in trying to criticize the judgment, you may end up appearing to impute bias, partiality, some impropriety to the court. And if you cross that line, you are in trouble.
All right. Yoni, you see why you should have been in the studio instead.
Yeah. But
you have more able people, my senior and big brother and brother Atta, my senior Atudazi.
Anyway.
Kweku should stop apologizing that he's not a lawyer. The law.
So you should stop apologizing that you're not a lawyer. Okay.
With
right.
logic and common sense. So Kweku is my lawyer. He knows that.
Anyway, my invitation to you is a standing one. I'll make it public. So in due course, you'll be in the studio. Thank you very much, Yoni Kolendi.
Great job you are doing.
Thank you.
Just one riposte to what my good friend Kolede was saying. I agree with the sentiments he's expressing, but I'm afraid he was answering the wrong question. You understand? If you ask the wrong question, you get a wrong answer. I never said that Betty Modidusu refused to go to court.
You gave a condition.
Exactly.
And the condition is that unless it is lifted.
Yes. Oh, no.
And you are being told that the place where you go to the court and say, I cannot speak about this. And the court will consider.
That it is for whoever received her application to say probably what he is saying. You see, it said, come to court. If he refuses to come to court, then you could be making the assumption that he's saying.
All right.
But just before, you made heavy weather about, what do you call it, Exhibit 32, isn't it?
Yes.
That was a little letter that was leaked, or so-called, from the Attorney General. You say, why was it leaked? How did Woyome get that document? That document is what do you call it? What do you put it? Confidential document and whatnot. You are relating to this same question of confidentiality, oath of secrecy, and whatnot. I'm saying that it's a serious business.
The group, the Right to Information, are very angry at you. And one of their officers is saying, please, is the former chief of staff saying that the oath of secrecy applies even when the issue is of public interest? No, I don't think so. This is why we need the access to information law. If that law is passed, it will override all laws relating to secrecy.
Maybe they are listening to somebody else, but certainly not what I've said here.
No, so this is how we do it. Else. Let me get you some 30 seconds, and then I get Yao, and then we'll move on. Yes.
I'm afraid I don't share the views of my senior on my left, because at the end of the day, it is for you to appear before the court, and then they want you to divulge certain things. Then you plead that I've sworn an oath of secrecy, I'm not supposed to divulge it. And then the court can even hear the matters in chamber and determine as to whether or not you should divulge it. That is the point. But you cannot say that I need somebody to clear me. Who is going to clear you? Because the very law you quoted is very specially permitted by law. So who gives the law, you give the special permission? The court. You can't, it's not Attorney General that will give another ex-Attorney General the permission to testify or not to testify. So it's a matter of you appearing before the court. They are probing into matters that will divulge national security. Then you could plead, have an oath of secrecy not to divulge some matters of national security. And that is how it goes. So that is something very important. Probably, I can assure you that why should anybody say that is in the Attorney General Department? Attorney General Department is prosecuting a matter of such national importance. In fact, some people even believe that you have some questions to answer. That was a very fine moment for you to sort of man the witness box, because you have not been charged, to show that indeed and in fact you also, bewitched, or you lost it, or you forgot it, or it was a mistake. But to say that, oh, I didn't have the clearance by reason of oath of secrecy, it's not.
Which issues are actually within?
Which
issues are actually within the domain of the Supreme Court to determine? Now let me hear you 30 seconds, and then I finish with Kokubaku. Then we'll move on to the questions, the petition to the president by Woyome, and also Martin Amidu's claims, and all the Occupy Ghana, the MPP, and the MPs who are saying the AG should step aside or some other form of thing should be done. And the reply from Tony Later and the AG as well.
I think an issue has been raised about the likelihood of bias by the judge, in the sense that he may not have examined the evidence in totality. But I think in recent times, the bar to determine whether a judge is biased has even been raised. And in the recent case of Republic vs. High Court, Party Republic Bank, HFC, and so on, Justice Atuguba referred to an Australian case, and in fact cited with approval, where obviously they have raised the bar, and I think by this judgment or ruling, we have also adopted that. And just a quick one, this Australian case of Laws versus Australian Broadcasting Tribunal, 1990 HCA 31, where it says that a reasonable bystander does not entertain a reasonable fear that a decision maker will bring an unfair or prejudiced mind to an inquiry merely because he has formed conclusion about an issue involved in the inquiry. Then I will just jump a few. He goes on to say that what must be firmly established is a reasonable fear that the decision maker's mind is so prejudiced in favor of a conclusion already formed that he or she will not alter that conclusion irrespective of the evidence or arguments presented to him or her. You remember that the Deputy Attorney General compared the judge's, if you like, in court conduct to a person who had fixed some inscription.
His headmaster.
Yes, and said that I've made up my mind, don't present me with the facts. I think it's as unfortunate as all of us can imagine. But the litmus test now is whether or not any other person, any other decision maker, when he is presented with all the facts and the evidence, would have come to a different conclusion from what this particular judge.
You don't think that he may have had a bit of some basis to make that, analysis? Because he says, when you read the judgment, and you have read it yourself, there is no analysis of the accuser's, case. The analysis is an analysis or a critique, rather, of the prosecution's case only.
Yeah, that is why I still go to the initial point there. The judge believes in the fact that after the prosecution has established its case, the prosecution has established a case against the accused person. And so whatever the accused person said subsequent to that, in fact, can even be set aside by the court. I think that is why the judge even used the word supported Justice Atuguba's opinion about the prima facie case.
Okay, thank you. Now, Kweku, let's see if you can also finish quickly.
Yeah. Glad that I have not attacked the judge. At all. Attacked the judgment. And this has been a long-standing commitment I've had over a period. See, if a judge, in giving a judgment based on everything that was presented to the court, suggests that, and he agrees in this, making this point, it was in agreement with what the defense had said, that accused had never, ever, at any time, claimed anywhere that Bank Austria deposited some monies in an account on behalf of Ghana government. And because of that, anybody who is making the claim that the man had made such a petition or anything was wrong.
He took time to analyze that, yeah.
The point is that Mr. Woyome talks of a documentary financial instrument, which, according to him, would have, now they say, that's what they are saying, would have brought in the money.
Right.
Now, he demanded 2% of 1.2 billion euro. First was 4%, negotiated down to 2%. 2% of a documentary financial instrument valued at 1.2 euro. The judge gives this value in his judgment.
It's true.
The Bank Austria indicates to you that that was a mere letter of support, of no commitment, and that at no point in time had they agreed that any such projects would take place. That's fact from them. The chairman of the Financial Evaluation Committee, who was a deputy governor of Bank of Ghana, appears and also tells you that yes, that is what it is based on banking practices. That's all, just a letter of support, nothing else beyond that. I cannot imagine why a judgment should put more premium on what two ministers, though lawyers, but they were acting as ministers, we root on the Public Procurement Act. I cannot understand it. Yeah. You may say I'm a layman, but it is unsustainable in law.
Just a second. I think the court relied on the position of the law in Fusua and Edipoku that it was settled law that documentary evidence should prevail over oral.
That's right.
Evidence.
Is that so?
That's right.
Is that so?
Yes. So
no.
So the sorry. And in law we have two types of evidence: oral and documentary. And we've been told that the documentary is quite superior.
No, but I'm saying there were two levels of documentary.
Okay,
the documentary the judge was
relying on. Let's not have another round.
Let's not have a comment on what
let me finish. The documentary the judge was relying on was the Betty Mould, Betnodro letters and Paul Asmenu's letter.
Yes.
These are documentaries. The one that came from the Bank Austria was not documentary.
It was.
Was it? Thank you. Now, so what are we talking about? So there's a clash here. Yeah. You then evaluate the weight of those documents and see where actually the weight, the credibility or so lies. That's the way I see it. Yeah. Now the man takes Paul Asmenu's letter, for instance. Paul Asmenu was a member, apart from being director legal, was a member of that committee. Apparently, he never even attended any of the meetings. The chairman of the committee's evidence is undermined by the letter written by a member who never even attended the meeting. What are we talking about? Please. I mean,
okay.
If I just a second to respond to some of
yes, please do.
You see, Kweku, the problem you are having is that you do not appreciate the fact that the Attorney General did not see what you are telling us. And I'm regret to tell you this, because that is the presumption. How come, with all the expertise of the Attorney General at the all material time, these evaluations you are making were not seen by the Attorney General?
Totally but rather, because in the closing
address, rather the Attorney General confirmed.
No, let me preempt your conclusion. In the state's closing address, some of the points I'm making are made there.
Okay.
For instance,
Thank
the
you.
procurement
Gentlemen, sorry, but we have to move on, and we need to deal with the matters that have come up after the judgment. But before we do that, I just want us to pay attention to Article 135. Article 135 is on production of official documents in court, and it says that the Supreme Court shall have exclusive jurisdiction to determine whether an official document shall not be produced in court because its production or the disclosure of its contents will be prejudicial to the security of the state or will be injurious to the public interest. That is 1351. 1352 says, where any issue referred to in clause 1 of this article arises as to the production or otherwise of an official document in any proceedings before any court other than the Supreme Court, then the proceedings in that other court shall be suspended while the Supreme Court examines the document and determines whether the document should be produced or not, and the Supreme Court shall make the appropriate order. Thank you
This quotation
much.
is completely misplaced and irrelevant. I'm saying we are talking about a letter from an individual to Attorney General saying that can you do ABC, consider these things. The matter hasn't come to court as far as she is concerned.
Senior respect. We are taking a break at this point. We'll be right back. This show is brought to you by MTN everywhere you go, and also by Bank of Africa, strong as a group and close as a partner. When we return, we have a bit of, okay, Nana Todazi says he's leaving at this very moment. He has to catch flight because he has an emergency to attend to. We're hoping that we could stay with you until 11 because that's what we understood the arrangement would have been. Amaliba will take his place. Abraham Amaliba will take his place. Thank you. Thank you very much, Nana, for coming. Okay, we'll take a break here. I'll be right back. You're welcome back. This is Newsfile, your most authoritative news analysis show. Nana Todazi just took leave of us, and he, in his place, is Abraham Amalba. Thank you very much for coming, Ebi. Yes. Your first time for this year. Yes. Thank you very much. Right. Now, a few of your text messages. This one says, "Can I get the law clear? Is Nana Todazi saying administrative mistake cannot be considered criminal?" And then this one, you don't identify. Okay, this one is from Mohammed Amin in Obuas. He says, "Samson, why don't you also make Kwesi Pratt Jr. a permanent guest with Kweku Baku in order to balance the panel on your program?" I don't know what balance you're speaking about, but talk to Kwesi Pratt. If he's interested, we can have him. Kwesi Pratt is not interested in being on this show. The position of the Supreme Court, that contracts. We wanted to say contradict. That contracts, those contracts are null and void on the grounds that they do not have parliamentary approval is problematic and detrimental to Ghana's international reputation. You didn't identify yourself. This one to you don't identify. Why? Please identify yourselves. This one says something. I need education on whether or not a person awarded a contract by government is to send the contract to Parliament for ratification. Obviously not. The state should be interested in how to retrieve the money from Woyome and discontinue the appeal against the ruling of Judge Nassam. Alhaji Moshood in Baku sent that one. Justice in University of Education, Winneba says, Kumasi says that, please, how can I get the judgment to read? The judgment is available at the courts. That's where we procured it. I'm sure subsequently it will be posted online so that you can have it. I think maybe after today, I'll make it available to the online team, and let's see if they are able to upload it for you to also read it for yourself. This one says, in fact, Kweku Baku is from a different planet altogether. What a level of intelligence. He has no class, even though he's not a lawyer. You don't identify yourself. This one from Dave Begro says, please, is the judge saying that Osafo Mafo and Ajiman Menu testified in favor of Woyome? No. Right, the judge didn't say so, but the cumulative of the evidences that they gave and everything else, there's a suggestion that things went against the state, and the state could have done better. And more importantly, that material witnesses like Betty Modidrisu Batinodro, Nekwe Tete, who was in the Attorney General's, whose wife allegedly got some 400,000 Ghana cedis and all of that mysteriously, you know, were not called as witness. And Paula Simeni, who was the head of legal at the finance ministry, who wrote to advise that the payment was right, were all not called. Well, I have asked the question about that if the judge felt that these people were so material that their evidence or their testimony could assist the state in the public interest and in the overriding interest of doing substantial justice in his inquiry, why did he not subpoena them as a cause witness? I have asked that question. Yeah. Nana Todazi agrees with me, and he says if that had been done, maybe Betty would have appeared. You disagree.
I totally disagree.
Why do you totally disagree?
Because you see, in a criminal case, the prosecution will have to assemble your witnesses and your evidence. You are saying that an accused person should be denied his liberty, his right to liberty, because you reasonably believe that he has committed an offense.
You're saying a judge can call a witness as a court witness only in a civil matter but not in a criminal matter?
No, even in a civil matter, the court is not in the business of doing cases.
So the court has been doing wrong thing. Is that what you're saying?
Oh, no, but usually, for example, a surveyor, it is the parties who apply.
No, I'm not talking about surveyor. I'm talking about
very important.
The court
The
on
court-
its own motion.
Oh, yes, but of course, when in issues, for example, quantum merit.
No, I'm not talking about that.
What I'm
Like
saying
in a
is that
criminal matter.
in a criminal matter.
Yeah,
I'm
you
saying
say
that in
that
a criminal matter,
The
that
judge
should
cannot do that.
That should not be done.
What happens to Section 68 of the Evidence Act? Courts may call and examine witness. Let me just read it to you. Section 68 of the Evidence Act says, 1, subsection 1 says, the court may, on its own motion, or at the request of a party, call or recall a witness. 2, all parties may cross-examine witnesses called by the court. 3, the court may ask questions of witnesses, whether they were called by a party or by the court, and so on and so forth. Yes. Of course, there's also the authority that the authority of Nyako versus the Republic, 1974, one Ghana Law Report 206, in which in the head note 2, it says in a criminal trial, the judge had by Act 30, Section 119, a discretion the defense and to call a witness not called either by the prosecution or without the consent of either of them. If, in the judge's opinion, it was critical, he could have called them.
Yes,
But in any case,
in fact, the judges do this, but they do this reluctantly.
Right.
It is not as if it's the usual thing. They will not assemble your witnesses for you.
Not at all.
But when it is of a matter of national interest, as at this, the court can subpoena. And this case and these cases that you have talked about support the claim.
Okay, now shall we move on? And okay, too many of your messages still coming around this issue. I think we need to move on. We still have a lot to discuss around the same issue. Now, Mr. Woyome issued a statement. In fact, it is a petition. Thank you very much. Forgot that I gave it to you. He, on the 13th of March, 2012, this is coming from the office of Alfred Agbesi Woyome. And he says, Dear Madam, demand for your resignation, stroke stepping aside as an Attorney General of the Republic of Ghana in the case of the Republic versus Alfred Agbesi Woyome. You know, and he first starts by saying he's surprised that the Attorney General is bent on going on an appeal just to seek his incarceration. Then he comes to give some points to say that the Attorney General was in a case representing Austro Invest, who was the client of the law firm that the Attorney General was working, and that they actually sought to take a share of the 51 million. They filed a suit in the High Court seeking to take a portion of that amount. Well, that suit was subsequently discontinued after it was filed, 3 months after it was filed. Then he claimed that he gives us photocopies of checks that were issued to pay an amount of about $1 million, is it? Yes, to a client of the law firm, later Brew and Co. Well, you have heard the Attorney General. The Attorney General says, no, it is not correct. Woyome owed them a debt, owed the client a debt, and they collected that debt. But questions have come up. Martin Amidu has also issued a statement saying that they acted for Austro Invest and they are in a conflict of interest situation, so she cannot, be prosecuting the case because she needs to be impartial. A lot have come up. Tony Leta, who is in that firm, has also issued a statement denying that they ever sought to take any money from part of the money, or they have received any part of the money, and that if Martin Amidu has any problem, he should report him to the General Legal Counsel for discipline. That's the appropriate forum to go. On this note, I'd like to start with you, Mr. Atacha.
Yes.
What do you make of Woyome's petition?
Well, in the first place, if we are not careful, it will sound very blackmailing that you are the one who is trying to prosecute me, and I want to prove that you don't have the moral guts to do it. That's on the surface of it. But the question which I want to find out, I'm trying to get an answer to, is that, is it a conclusive fact that part of the 51 million Ghana cedis was what was settled on the client of the law firm of what's it called?
Liter Brew.
Liter Brew. If it is true that what has been tainted with respect from the Attorney General's perspective, that this is, a matter of criminal proceeds. That's why they are prosecuting this man. The 51 million is criminal. And that's why there is also a spirited attempt to go and appeal. And you should say that some of the monies were paid to a client of the Attorney General's former law firm. And the only thing you can talk about is that, well, how do you stand in terms of moral judgment that you should have the benefit of the proceeds of a crime as part of your fees? So it becomes a moral issue as to whether the former law office of the Attorney General will say, well, it's now come to our notice that this is what happened. We want to retain the fees that we charge on it, because it will not sit well to say that what you are saying at one breath is a criminal matter. You should be the beneficiary of some of the fees. Apart from that, I do not think that there are serious issues to look at. The Attorney General might not be the one who is personally doing this. There are a lot of people who might be interested in ensuring that this case is prosecuted. So all that should happen is that I recuse myself because of these allegations from looking at this case. And there are other people who were never connected with this case, and they will do it. Because at the end of the day, you cannot use this case as a single example that the Attorney General should resign. I don't hold that view. But the only thing that I see as very critical is that, have you received the proceeds of what you call a crime? That's a moral issue. And when it comes to moral issues...
Okay, here are the facts as she narrates them. That her client, or a client of her former firm, Ray Smith, who was the sole shareholder of Austro Invest, was owed a debt by Woyome of the amount. And they were instructed to take the debt because he was not paying after a while. So they chased him through court processes or whatever, and then he settled the debt. Should they be bothered where he got the money to pay them?
Well, this is what he's trying to say, in essence, that you've been associated with this. The criminal case you are pushing, that I received the money criminally, I use it to pay a debt owed your client. The question is, and so that's a very serious matter, that were you a beneficiary of that amount of money by way of legal fees? You see, because as for lawyers, they will pursue you for the money. But if it should come to light that indeed and in fact the circumstances have changed, and I now believe that the monies that were paid to my client were the proceeds of a crime, then all that maybe you need to talk about is that, well, for strong moral reasons, I don't want to be at this high level of power and authority to be a recipient of the proceeds of a crime, and therefore I want to return the money. But to say...
So does it matter that Tony Lita, who I suppose is the head of that firm, comes out to say that I, Tony Lita, took all the instructions in respect of Austro Invest and Ray Smith. I did all the legal business that this gentleman wanted. So later, Mrs. Brew, Marietta Brew Apiopong, had no business whatsoever directly as counsel in that firm to handle that brief. Doesn't matter.
It does, if they are partners.
Yes, they are.
Yeah, if they are partners, then you know partners will share money. Whether it's X who is doing the job and the other one is attending to the other matter. But aside that, I do not see how you could say, in the strictest sense, that you shouldn't appeal. I wouldn't want to accept that position. Because at the end of the day, if this Attorney General does not appeal the case personally, there are other people who appeal the case. And I'm very, very, very cautious to come to a conclusion that the Attorney General should resign on the basis of the facts as set out by Mr. Alfred Woyome. I don't think it's a very, very critical matter. The only thing that I've told you is that if there are monies to be disgorged, fine. based on the fact that they were working as lawyers.
Okay.
But
well, how about if Woyome's own is groundless, so to speak? How about Martin Amidu? You have read his statement. You have read subsequently what he issued out again, another rejoinder, in which he produces an affidavit which he filed at the Supreme Court, which sought to actually support Woyome when they tried to resist the manner in which the Attorney General proceeded to recover the 51 million. They accused the Attorney General of being selective in the entry of judgment, that by the review decision, the orders were not just an order directed at Woyome, but they were orders, some of which were directed at Austro Invest or whoever were involved as well. And yet she went to the Supreme Court only targeting Woyome.
But I hear
Yes.
Austro Invest is defunct.
Yes.
So how are you going to, exact entry of judgment and serve on a defunct company? So from the professional judgment of the Attorney General, you can't pursue a ghost. So where is the bias in this? I can't fathom that. But if it is said that you have extracted an entry of judgment which is false to favor Woyome, then I could say that, well, then your moral standing...
Not to favor Woyome, against Woyome in favor of your client, because there are aspects that are against your former client, which aspects you don't bring up in the entry.
Well, I think it's a professional judgment, and as I'm looking at it from this perspective, because I've been educated that when a company is liquidated, I mean, then probably you need to extract the entry of judgment and slap it on the liquidator if there are leftovers for you to, get some money.
Because a liquidated company cannot hold an account.
Yes.
Okay.
Yes. So this is how I say it. Apart from that, there must be some serious problems there, but so far as I'm concerned, is the entry of judgment false? Is the entry of judgment criminal? Does it not reflect the decision? But if I'm extracting an entry of judgment and I know that the company is no longer in existence, then I should use my professional judgment is that it will be laughable. I'm sure by now you'll be laughing big time that here is an entry of judgment which attaches to a ghost. So probably we should look at it from that perspective,
okay,
and give them the benefit of the doubt.
Take a breather. Kweku,
Yeah.
I want to get your perspective, then I will hear the lawyers. Yes.
See, Woyome, he just threw out the red herring.
Red herring?
Yes. Woyome is quite a crafty guy. Even though I think that most of his claims have been of dubious validity. I don't trust him one bit. I'm not being personal. It's based on the track record that he's established for himself. Now, look, let's be just straight. The point he makes here, I'm reading the third paragraph, or the fourth.
Okay.
Yeah, fourth. I find it difficult to reconcile your decision to involve yourself directly in this criminal case and notice of appeal you have authorized to be issued and served on me. It is a fact, stressed, it is a fact that you and your clients received approximately $1 million equivalent in Ghana cedis from the said judgment debt you now so much criminalized and want me jailed for. The CD equivalent was so and so and so through an agricultural development bank check, number so and so and so, in the joint names of Ray and Engelberg Smith. This is the check. Where is the evidence that this monies came from the judgment debt? Where is the evidence that these monies were paid to Marita? I mean, this, even on the face of his own letter, that's nothing. And yet you had people running after this and thinking they had something to throw about. I was shocked.
So if he's able to show that it is out of that money that he paid, what will you say then?
No. Now you say if. The man put out some material incriminating somebody of very serious consequences. Right then, at that material moment, if I were him, considering all what had happened, you put out the facts. You don't put something that does not meet the allegation you are saying. For us now to come and see and say, if what happens in future if it breaks. Look, what people should be asking is this. Has Woyome given any monies to Austro Invest, even if it's defunct, or before it became defunct? because the two of them conspired in making the claim. Okay, the two. And let me give you the evidence. This is a letter the Austro Invest man, Ray Smith, as Chief Executive Officer of Empower Park, wrote to President Mills, dated 19 December 2011. It's just three paragraphs. You want me to read, then I establish a fact for you.
Go ahead.
It says, the matter of Alfred Agbisi Woyome, Your Excellency, I am aware of the turmoil which the above is generating nationally in the media and which disturbs me greatly. Over the years, I've had a close relationship with the person, and I wish to make known to you the facts surrounding this matter, since there's so much speculation and untruth being released in the public domain for which is far from the best interest of your government. I therefore wish to present to you a factual report for your consideration. It will appear to me that the gentleman is generating unnecessary havoc and is more interested in his own misguided political ambitions than working truly in the best interest of his party. This is very strictly a personal view. I hope that the attached document will be of some assistance to your investigations. Now go to the attached document.
Did he write this, sign this himself,
yes,
or it was written by his lawyer?
Signed, Ray Smith, CEO, Empower Park Limited.
Right.
But attachments, that's where the meat is. And one of the attachments was a email from Ray Smith to Mr. Coker, apparently was Woyome's lawyer. And that under the heading, Woyome / Austro Invest Management. It says, together, we were responsible for the financing of projects which in the hindsight were illegally cancelled by the previous government. This has proven by recent events to be admitted. Clearly, there was a case to be brought against the government for suitable recompense. The position taken by Mr. Woyome was that in the event of such case being successful, then there was a valid case of persons in previous government being held responsible for loss to the state. And this was the determination of Mr. Woyome for his personal reasons. Under these circumstances, there was no way in which the directors of Empower Park, both expatriate, and one of whom being Austrian Council, that is his wife, the other director of Austro Invest, could possibly contemplate involvement, meaning the litigation. It was therefore agreed that Woyome will proceed in his name alone on the basis of good faith. And in view of this, an agreement was established to share the proceeds in the ratio 5/9 for Woyome, 4/9 for Austro Invest. And this remains expected on a fair and genuine grounds. They attached a so-called agreement, which I suspect was backdated.
So this is why he later sued.
Fantastic, because Woyome refused to give them any money. So we must ask Woyome, has he delivered? Did he? Because as far as we know, he refused. And that's why the Smiths went to court.
But they withdrew, they discontinued it after 3 months.
So, you see, what is important for us Ghanaians is for Woyome to give us evidence that, look, indeed, I gave $2-3 million to Austro Invest, even before perhaps they got defunct.
After share.
Yes, he's not telling you that. He's chosen a diversionary one full of mischief. That, oh, you took 1-something million from the judgment debt. Where's the evidence? Even on the face of your own checks. There's nothing to run with. Martin may have raised serious points, more substantive, even though that too, as Atai says, some areas are contestable. But Woyome's one...
Martin is saying that the claim for the money was made in the joint names of Woyome and Austro Invest. So they are supposed to be joint beneficiaries.
Yes, but Woyome cheated on them. Clear. That's no doubt about that. That's why I'm saying that if he reversed he negated the cheating and indeed subsequently paid, that is where we are interested in.
So what was judgment debt lodged? In which account? Is it
Woyome's account.
Agreed development bank account?
Yes. It's all documented in the court proceedings. Am I right?
But with the letters, like agreed development bank check.
It is.
No, it is. It is.
So what is the problem then? The material time.
Yeah. I don't get
you're questioning about whether or not the money paid.
But Woyome had plenty money. He had money already in the bank.
Okay.
That was his account that he's been running. It is not as if that money was this account was specially created for the judgment debt.
Okay.
Let's not be clear about that. But I'm saying that it is immaterial because if you look at the court,
there's a record that's not in the public domain yet that the money was routed through some bank account before it went to Woyome's account.
Well, but the documents from the Finance Ministry, Attorney General, all shows that pay into so and so account. All those accounts were bona fide accounts of Woyome.
All right.
Now the point is that he attached also some court documentations that makes you see what the litigation was about.
Sure.
He was in litigation with those guys over something else, not the judgment debt one, which was discontinued. I don't know whether you've seen those court documentations. The rates, it was different. So, you see, as for the Woyome intrusion, this demand and the things that it contained, I thought we should have dismissed it as fast as possible with contempt. It had nothing of value. And yet, you had communicators and politicians and things running after it. So, my goodness, about in the Wisigara. Incredible. Look, let's elevate the quality of the discourse and the debate, and not run after red herrings of this sort.
Okay, yeah. Let's hear what you have to say. You have also been going through all the documents.
I've looked at the check, and I was wondering whether the date on the check may be of assistance to us, because the first one, which is Ray and Co., is dated 06-1011. I don't know whether it's 6 October 2011, or as the Americans do, is June 10, 2011. So whichever way you see it, that date will be significant to us, because it's, at least let's take it the way we write it, so it should be 6 October 2011.
Yes.
The second one too is 6 October 2011.
Yes.
So those who have the evidence of when payments were made.
No, but that is of no consequence.
Well, just a moment. Yes, I know, but
it's of no consequence.
But
in terms of finding out whether it was the judgment, the part of the judgment that was paid or not.
Well, but
go and check the court records. They were litigating in court over something.
Saying there could have been a lot of money sitting in that account before
already.
This one
well, for me, even if it's from the court, the judgment debt is of no consequence to me, because I mean, once the lawyer has worked. And it's not about whether or not the money was paid to these parties. But the issue is whether the lawyers got a portion of it. But if a lawyer has worked for his client and monies have been properly recovered, then what is the business of finding out whether these monies were...
This case, you are a lawyer.
So let me go on. Let me go on with the case itself. I'm saying that
two cases.
Looking at even the cases, there appears to be some confusion as to where the real purpose of even this money. Look at the first suit, all right, and it's suit number AC 527/2011. Now it's between Ray Smith and Alfred Woyome.
Right.
Now, paragraph 3. In or about 208, upon the request of the defendant, that is Woyome, the plaintiff, Ray Smith, lent to the defendant a sum of $982.929.53. The money was an investment refund due to the plaintiff from a business engineered for the construction of stadia for the government of Ghana, involving Austro Invest Management, a Swiss-registered company wholly owned by the plaintiff, Waterville, an offshore company registered in 2002, and Empower Park, a locally registered company. So if these companies were involved, how does Ray Smith come in?
Ray Smith is part of Austro Invest and Empower.
Well, we are talking about companies. So even if a company has earned some monies from you, you don't issue the check in the name of an individual.
Okay, go ahead.
But it says the plaintiff lent.
Yes, so that is where I'm coming. So if the individual now becomes a money lender,
100% shareholder of a company.
Yes,
he is.
He now lends money. We are not saying that the money came from the company, but the individual who lent the money for the purpose of ensuring that these companies that have been listed here were able to perform the project, right, for the construction of the stadia.
Yeah, but Woyome agreed he owed them, so he paid them.
I'm saying that let us even look at who was paid.
Who was paid?
Yes.
Ray Smith.
We know Ray Smith was paid.
Yeah, so if Ray Smith was paid, then where is the connection between the project, all right, and Ray Smith? First, we are saying that Ray Smith lent Woyome to enable him perform under the contract.
They were all together. They were together.
Sure.
Empower Park, VAMED, Australia.
but
They created a certain weird octopus.
But Kweku, my point. That is why my that is where my point. That is where my point.
It was an
you see,
octopus.
that is where my point comes in. So the attorney generals
To defraud.
the attorney generals from Chambers acted for one Smith. Never acted in this particular case for Austro Invest or Empower Park. In relation to this case.
Yes,
in this case,
yes. You're right.
Then another
There's
suit.
a second suit, yeah.
Yes.
AC 96 2012. This is between Austro Invest Investment and Alfred Agbesi Woyome. Right. In this case, they are the plaintiff is claiming another compelling defendant to pay to plaintiff forthwith the sum of 5,068,960.
Sure. This is what we should find out. Has he paid?
Yes. So
This is where judgment day. This one is the one.
So let us hold on. Now,
Thank you.
let us look at the checks. Because as we said, one is to Smith and the other is to Empower Park.
Yes. That one, you know what happened. It would not be fair to tell the full story.
Well, if you know
Yes.
it,
Oh, no,
bring it up.
I have the
So in the circumstances,
Yeah.
does it not even matter that the law firm,
Yeah.
Later Brew and Co.,
Yeah.
had sought on the instructions of their client to procure a part of the judgment debt, controversial money, 51 million, for their client, albeit they subsequently discontinued the process because they issued this rate to get from Woyome a part of the money.
It's actually this was
Confirming-
2012. This case was commenced in 2012.
confirming what Martin Amidu says, that the monies were claimed in the joint names of Woyome and Austro
That one
Invest.
is true.
Yes. And
All
so
the
that
letters
is
to
in
Becky
paragraph
and
3
things,
states it. You know about 205, 206, the parties working as a consortium
Right.
under a company known as Waterville took part in an international competitive bid by the government of Ghana aimed at sourcing. So this relates specifically to the
the money.
judgment debt
Yes.
that was
Yes.
paid to Woyome.
Thank you.
And that is where then Kweku is asking whether he paid.
Yes.
But then that
Which he
brings to
won't
focus
disclose that.
the second check, Empower Park. On what basis was that check also issued?
Perhaps it's not fair for me to disclose what I know. I think it's a bit irrelevant to the issue we are dealing with. But there's a report here. Don't forget, when Reese Made got ill and left the jurisdiction with his wife for a long time, they left Empower Park in the hands of Woyome. He was running the show. Now they come back and have difficulties with the accountants after some auditing processes. It became a huge thing. They set up an investigation. It was led by Focal Intelligence. I think that's Raymond Archer's group.
Yeah.
And Raymond Archer's group submitted a report. Eventually, after discussions, Woyome agreed to pay back the monies that were deemed to have been lost. That's part of that.
Okay, so let me conclude. For me, whichever way we see this, whether per the Woyome letter or Martin Amidu's one, I think that the people of Ghana has set a very difficult test for the Attorney General. And I think people will not, that suspicion will not be dispelled by responses to these gentlemen or the people of Ghana. People want to see practical steps so that if the managing director or the manager of a branch of one of the banks is served with a document from the court, yeah, that he should come to court. I don't want to just make it too complex, but he should come to court to justify why any money standing in the name of Woyome should not be paid for and for the benefit of the state. That managing director will then tell his friends, "Oh, Charlie, the people are serious. They've started."
Well, we are told that
recovering
we
the
are
money.
told that they have done their search. There are no money sitting in those accounts.
Well, please.
Yes, but they are sure of how they intend to recover the money.
Well, but then usually you don't use this process. Let the bank, first of all, it will be established that he has an account. It will be established that the monies were paid into that account.
You are saying
It
that
will be
they
established.
should garnish them.
Yes,
to
I didn't
recover
want
the
to make
51
it
million.
complex because, as you said, a lot of the people is.
But already they are taking directions on how to enforce the judgment.
And that is where I'm coming to.
found it.
Earlier on in the Asofoton case, the Attorney General went to the High Court for purposes of
Both of
enforcement.
them, for two, or the two.
And their lawyers, my good friend Tadio Osori, brought them to the Supreme Court. That when you have given judgment, the people have rather gone to the High Court to enable them enforce it. And the court held that the Supreme Court has enough procedures for enforcement of judgment of this kind. So the last time they came to court, and I was there for this application, I asked myself whether, I mean, how different is this one from the isophoton case? Because if the isophoton case clearly has stated that you can use the normal processes of execution to recover the money, then I didn't see how they could then still go back to the Supreme Court for direction in this matter. Because if you don't take care, what will happen is that since there is no, if you like, quote unquote, injunction against he disposing of his properties, if he does so now, you cannot charge him for dissipating his account.
Okay. So the point now to look at now is Woyome says the Attorney General should step aside or resign, and Martin Amidu supports him. There are others who also support him, including the NPP and Occupy Ghana.
Oh, well, as I referred...
Is there grounds for her to...
No, I don't think so, especially based on issue of partiality or lack of impartiality.
Conflict of interest in the prosecution.
As I said, and I referred you to the Australian case. I think the bar has been raised above that. Secondly, she is not the judge, and she doesn't work alone. Of course, she determines which case, and if indeed she does not want to recover this money, which I'm saying that is more important to me than the incarceration of Woyome, even though that may be important.
Right.
What we are looking for now is for her to take these practical steps. And these are the steps that will then dispel all these issues of resign because you are not likely to be an unbiased decision maker. If she takes these steps, and we all see, tomorrow, just a second, tomorrow Woyome's neighbors will see that some of his houses have been attached. You think that people will still hold on to this perception of bias?
Okay. Now I'm going to hear from Abraham Amaliba, but before we do so, let's hear from the Attorney General how she responded to Woyome, what her response is. Let's hear quickly.
When I saw it, I was quite upset, and then, of course, I gathered my wits around me and decided, let me look at what this gentleman is saying.
What was it that upset you about it?
His claim that my firm took and our clients received approximately $1 million equivalent in Ghana cedis from the said judgment debt. That upsets me because it's complete falsehood. And he himself has attached the documentation that show that it is false.
And which documents are?
There is a case, a writ attached to this, Ray Smith versus Alfred Agbesi Woyome. And when you see or read the content of that writ, you realize that Alfred Agbesi Woyome, in or about 2008, gave or took a debt from Ray Smith in the sum of about $982,929 United States dollars. 2011, he hadn't repaid that debt, and so Ray Smith instructed my firm, and indeed it's my partner Tony Letha, my former partner Tony Letha, who represented them. He sued Alfred Agbesi Woyome for recovery of this money on behalf of Ray Smith. And again, Mr. Alfred Agbesi Woyome attaches the checks that were issued to Ray and Ingeborg Smith in the sum of, and you see the checks are attached. And so the payment that was made by Alfred Woyome to Ray and Ingeborg Smith was in respect of a debt he owed Ray Smith, and for which we initiated action on his behalf. In the first place, we've never worked for Alfred Agbesi Woyome. Never. My firm has never worked for him. In the 4 cases that are before or were before the court, I think 2 are still pending from what I understand.
I'm not sure he's claiming that, though, that your firm worked for him.
No, but so how would we have benefited from that money if we didn't work for him?
Essentially,
Because there have been two stories since last week. First, they said we represented Alfred Agbesi Woyome. And then, of course, Mr. Letha went on one of the radio stations and said, no, that is not correct. We've always been on the other side. If he's plaintiff, we represent the defendant. If we represent the plaintiff, he is defendant. And so we've always been, that's my firm, and represented by Mr. Tony Letha, because he has personally handled these cases. I never personally handled anything involving Alfred Agbesi Woyome, but it was my firm at the time. We were always on the other side. As far as I know, and as far as the documents he has provided, the truth is that he owed Ray Smith. We sued him, and he paid him a debt he owed. For what reason should I resign? There's no conflict. I'm doing my work as Attorney General. There's been a judgment. The people of Ghana, as you can see, are very unhappy with the decision of the court. We filed an appeal. I'm pursuing it. What is there to call on me to resign for? There's nothing. There's absolutely nothing.
Right, so that was the Attorney General, Marietta Brew, appeal upon Attorney General and Minister of Justice. Now, as I did the list of the groups and persons who are calling on her to step aside or resign, I added Occupy Ghana to that list. Occupy Ghana's statement actually is calling on her to quickly retrieve the money. They are not calling on her to step aside. To quickly retrieve the money. They think that it's unthinkable that a judgment that was procured in 2013, we still do not have the money. It's surprising to a lot of people. It won't happen in my firm. Yes. What do you say about all of these things?
In terms of Woyome, but not what have you. Woyome's came subsequently.
Okay, through the
2014.
okay,
the review.
The review. Thank you. 2014. Okay.
Yeah, something. Let me start by saying that when we take the letter written by Woyome, I have had discussions with some lawyers who are close to him, and the indication is that this was done without their consent. In other words, they did not sanction such a letter. And so that letter, I describe it as a red herring letter meant to divert attention. And it has succeeded in diverting attention because we have, over the week, been talking about that letter. But that letter...
Mr. Namidu supports him, don't forget that.
I'm coming to that. That letter is diversionary in nature. There's no substance in that letter, and I'm not going to repeat all the things that Kukubako has said about that letter. On the issue of Martin Namidu, apart from the fact that he was trying to drag in the president, which I have reacted appropriately, I think that his claim of the AG not being partial, or the AG, as it were,
not being impartial.
Not being impartial, and that the AG would not look at the issue without ensuring that Woyome is sent to court. I think that impartiality is not a word to be used for an attorney general. Impartiality is a word to be used for a judge. What I think they could be talking about is that the AG should have an open mind and not to be prejudiced by maybe the facts. If you look at it from that angle, then I think that the AG has actually looked at this matter dispassionately and has come to the conclusion that there's a question to answer. That's why she went to court. But to talk about the AG being impartial, it's not within the realm of an attorney general. In fact, part of the attorney general's work is to be partial. Because after he reviews the facts and decides to put you on trial, he has decided that he has to prosecute you. And that means that he's taking sides against you. If he doesn't take sides against you, how can he prosecute you? So for me, impartiality does not come in here. Now, I can tell you that I've had some discussions with Tony Letha on this matter. Tony is of the view that at the time that he acted for Astro Invest. It was only after what is his name, Alpha Woyome had gone in for the money, then he came in as a lawyer. It's not as if he was a lawyer to Astro Invest and advised Astro Invest to go in for the monies that are being disputed about. So when he came in, and I'm now touching on the issue of discontinuance, when he came in and realized that two things, that the company was liquidated, and secondly, that these were the monies, the 51 million was part of the monies that Astro Invest was asking for, he discontinued the case from my interaction with Tony. So when you look at the conduct of that law firm, I do not see how there is any conflict of interest in this. You would also want to know that in this same matter, and I'm talking about the Astro Invest matter, when Tony Lita was suing on behalf of Astro Invest, he got the hint somewhere and he picked signals that, look, the monies that Woyome is claiming, Astro Invest did not benefit from it. So as we speak today, Astro Invest, and I'm answering Koku's question, as we speak today, and as at the time that Tony discontinued the case, Astro Invest had not benefited from that.
Well, it is a liquidated entity. So
yes, so good. So had not benefited. And that goes to debunk Martin Amidu's point that they were beneficiaries, joint beneficiaries.
No, they made the claim jointly.
Yes,
they were
but they have not benefited.
Some benefits.
But they have not benefited from it.
That's something
no money was
Woyome
given
should
to
tell
them.
us. Woyome should tell us that.
And no, I'm saying that at the point that Tony recused himself.
Okay, at that point.
At that point,
okay.
no payment was made. They hadn't benefited from it.
Okay.
And so
I hear you.
Yes, so that must also be placed on record. Now, should the Attorney General resign, as she rightly indicated, what has she done to call for her resignation? These calls are unwarranted. They do not, as it were, based on any law. If the Attorney General herself decides that she wants to recuse herself, she will do that. But the circumstances surrounding all these things that have happened at the Attorney General's Department do not call for her resignation, because she has not been cited in any conflict of interest situation. She has not aided and abetted anything. Indeed, she is rather putting her best foot forward to try to retrieve the money. Now, on the retrieval of money, that is where I would side with Ghanaians, that there's a need for us to go in for the money. In fact, between the two, I would have loved it that it happened this way, that we lose the criminal case, but the civil case, there's still some, way for us to handle. It would have been suicidal if we had lost the civil one and won the criminal, because indeed the criminal would have been just that we are going to put him behind bars.
Well, the civil one was not by the states. That's one way.
Indeed. Let me also tell you that. Let me also tell you that before the Supreme Court did what it did, there was a civil case pending filed by the AG. Remember,
commercial court.
Remember that. Remember that.
That is what had been filed to seek to set aside.
Well,
you would also not forget that Martin Amidu was pursuing that as Attorney General before he was removed.
Martin Amidu, don't be calling him, when he was acting as Attorney General, was acting for the state. It's not an individual matter. So the state itself was already in court at the High Court trying to retrieve the money in the civil proceedings. So all in all, my view on this matter is that let's quickly go in for the monies. And when I had discussions with the AG, she says that she has filed processes in court to retrieve the money. Indeed, she said that they will be going back to court on the 30th or 31st, all in furtherance of retrieving the money. Within this week, we had the Attorney General office saying that they had gone to serve Woyome and Waterville some documents and they couldn't find him. These are all attempts to retrieve the money. So Ghanaians should be rest assured that the Attorney General is on the beat.
Do you know why the Attorney General's department rejected Woyome's? We are told that he had gone in to plead to pay in installment, and it was rejected. He had come to say, I'm submit to pay, and it was rejected.
Because indeed, I do not know the reason why, but sometimes once a judgment is given, you don't want to compromise the judgment, particularly in this particular case where there's so much public interest in it. It is for Woyome, and I can give free legal advice, to go to court and ask that he wants to pay the money in installment and let a court give that judgment. Then the Attorney General will be bound by that.
Well, in the original case at the commercial court, we had compromised the judgment how many times?
Yes.
Yeah, but that is what has brought up all these things. So you don't want to be seen again compromising it.
But if it is a state of affairs, that would be very weird.
Yes.
That the man owes so much money and he wants to turn in some of the money.
And you said,
And you say you won't take it. That would be surprising.
No,
That's what I'm saying.
It
That
depends on
it
the
is,
terms.
it is
First of
not
all, we
clear.
don't even have
It
the
is not
interest
clear whether the Attorney
equivalent
General has
here.
said
It
that.
depends
That
on the
is-
terms.
It is.
You don't just because he, so assuming he came and
If
said,
you
look, I'll
drop
pay.
a coin, it reduces the burden.
No. So he comes and he says, I'll pay a peso a day. So the
Look,
next-
oh, well, that even is an admission
Koku,
that,
you know what?
that he
Koku-
owes you.
No, but that's for an admission.
No,
This
Koku,
is
you know
not
what? When
forgiven.
somebody owes you,
Supreme Court has
when
ruled
somebody
it.
owes you and brings one CD, you take it.
Why not?
Because you never know tomorrow he will die.
No.
And you will not even get that one CD
His
again.
properties are
Even if he
available.
doesn't die,
I
he's
see.
at
The properties
liberty
don't
to
die.
dispose of those properties. Since no fife or whatever may not have been served on him at that
No, I
time.
think something's underway of that.
Yes, I'm saying that at the time, just before he was
Scanning
served,
the we did half.
does he even have any left?
He's chopped the money.
All right, now, if we may just wrap up here on this particular issue. Those who have directed their petitions to the AG, to the president, including the NPP, and we had MPs also in Parliament say there should rather be a probe of the AG and extend it beyond that, because too many people within the government appear to be complicit in this whole matter. You've heard Tony later say what I have said earlier, that if anybody had any complaints, it should be about the lawyers involved, that's the Attorney General, and if Tony later too is involved, they should take it to the General Legal Council, the properly constituted body to deal with the matters. What do you say to that?
There can only be an inquiry on this matter if there's established a prima facie case.
No, there ought to be a complaint first.
No, I'm saying that.
Who establishes the prima facie?
No, if people even go for the complaint, I'm saying we shouldn't waste our time. Because the setting up of the committee will be based on whether there's a prima facie case for the Attorney General to be called upon to answer. Look at those checks. They do not bear the name of the Attorney General. Indeed, there's no evidence from all these things to show that the legal fees of the Lita Brew & Co. came from the judgment. There's no evidence. Indeed, sometimes lawyers even take their fees ahead. They take everything before they do the case. So there's no evidence to show that that money was part of the judgment there. So why would you want to set up a committee for them to condemn tea for what?
I see. It's a standing committee. It's not a committee that has to be set up at the General Legal Council.
Well,
Tony actually has dared Martin Amidu.
I think that's an appropriate forum to go, and it will resolve matters. And as you've rightly said, some things are very diversionary. What we are interested in, and I'll support some of my friends here, that there is no time to waste relating to the recovery of the money. In fact, for the first time, I'll agree with my brother, though he doesn't agree with me at all. That I have said, some people might say that you don't have to go that route, but I can assure you that sometimes we want to make the society happy by giving us some fanfare to enjoy. This criminal trial, wherever you are taking it, the imprisonment of the man might be the ultimate thing. But what is of great benefit to this country, and there's a return of the money. Even if it's 90% short, 20% short, 30% short, is the Attorney General going to use every muscle she can master to retrieve the money? This is a test.
Most important.
Yes.
Yes,
30 seconds, and I'll hold you to it.
It's also important because in the past, people have been convicted for stealing state money. We did not pursue the recovery. They were imprisoned. Some kind of executive prerogative of mercy was issued. They were brought back, and they've been given further positions by the state itself.
So they have the opportunity to enjoy their booty.
Yes. So you weigh the two. going to prison and stealing state money? Which one? So you rather go to prison and come back when he has invested the money and enjoy the money. So my preference now is let us vigorously pursue the recovery.
Okay.
And if it will subsequently end up in incarceration, that is fine, but we should pursue it now. Otherwise, he is at liberty to dispose of his property before any such processes.
Thank you very much.
But not after the judgment. There can be tracing.
And as you can imagine by
When
now,
there's no
that money has yielded maybe threefold.
Yes,
and he's
yes.
going to pay without interest anyway.
Look, I will be blunt. I want both achieved.
You want
But
both?
which one first?
The recovery and the incarceration.
Both.
At the same time?
Yes,
Simultaneous?
yes.
Okay.
Both. That's
All right, so we
the
can
end of
proceed on that.
justice.
Yeah,
But Mr. Tony Lita, I sympathize with him. But you see, the irony of ironies. You make allegations against judges, say all sorts of things against judges. When committees are set up for you to come and defend yourself or defend allegation, substantiate allegation, you don't show up. You go out into the streets to join all sorts of groups and target people.
But Koko is not here to defend himself on this matter.
This is public record.
No, I'm saying that
This is public record.
for him to defend
I
this
know,
matter.
I know where exactly
No,
to
well,
stop
I
him,
said
because
I
what he's
sympathize-
talking about, we take judicial notice of. So you hold on, let him.
It is only a lesson, you see, that we should desist from leveling allegations against fellow lawyers, that is, me not included, of course, and judges. Anyhow, and get away with it. He's being paid back in his own coin. I'm sorry, but I sympathize with
the
him.
fact that you think that he did something wrong, the wrong should be
That's why
perpetuated?
that's why I began by saying I sympathize with him, meaning that what is going against him is a bit unfair when especially you don't substantiate it.
But you feel
he
that
did
this is
similar.
karma. Okay.
It's karma. It's the law of karma.
All right.
Thank you.
Well, but some say he's spoken well. He's giving the challenge. If Martin Amidu or anybody for that matter have any evidence against him, head to the General Legal Counsel. The implications will be that if he's found to have misconducted himself, he could lose his license to practice for a while, or he could completely have his name erased from the role of lawyers.
Something.
But you can also
he
see
could
those
have
making
done the
those
same.
allegations.
He didn't do it.
Okay.
When a committee was set up with Justice Brobe in charge, he didn't appear.
Okay, thank you. We take a break here. When we return, we won't do any more Woyome. We will head straight to find out how a suit to strike down the law that says if you are accused of rape, defilement, of murder, of narcotics, you will not be granted bail. How that helps the process to decongest the prisons, as has been taken on head-on by the Interior Minister and the Chief Justice. We'll be right back.